that we were discussing last week. So that all those changes were put on hold until the end of this year, to be reevaluated. So, we'll still, that gives us the rest of the year if anyone's challenges in court, or if the administration decides to shelf this rule, and whatever it might be. Like we said last week, they're still evaluating this rule and a lot of other rules, and the 60-day moratorium for this rule wasn't enough, so that's why they extended this until the end of the year.
Yeah, thank you, Lucas. Actually, we had some technical issue before it was not have the audio. Just we are discussing about today's topic, the fiscal year H1B CAP 2022 and the 485 adjustment of status who filled in October about their kids is crossing the 21 years. We can discuss today is the Biden new administration implementation plan. I think I see the couple of news today. Biden sent the new immigration plan to the Congress, and also we discussed about the per country quota. These are the topics today. It means I'm requesting to everyone, please participate every Wednesday show, and please do call to show. We provided the conference number on Facebook and YouTube. Just hang up and dial and directly connect to Lucas and get more information directly from Lucas. Or else, if you're busy, just post your question on Facebook and YouTube. We can address your questions. Yeah, thank you. Lucas, so what is there any update Biden immigration plan?
Well, yes. So Dick Durbin, a senator, and also Senator Lindsey Graham have put together a proposed immigration plan that in part is addressing the Dreamers, which would be people who have DACA, and also certain TPS holders that have TPS stands for temporary protected status. And this is a good sign for what we discussed a few weeks back, even going back into last October, where we were talking about comprehensive immigration reform. What does this mean? How would it impact us specifically in employment-based immigration categories? So, in the past, when something like this comes about for comprehensive immigration reform, we look to maybe rectify all the issues at one time in one bill. Everything's discussed, everything goes through, the House of Representatives and then Congress, and then the president signs. We can add amendments or small changes as needed. President Biden this time has actually been really vocal and open about what we would call like a piecemeal strategy. And what this means is, we're going to send this piece of legislation through affecting this group or this issue within in this circumstance, like for the Dreamers or whatever else, that can be debated and discussed. And next, we'll send another bill through that will maybe address the backlog and employment-based categories. So they're more or less separate subjects, which bodes extremely well for most people that are stuck in this backlog, where we actually have pretty good hope that if that's the case, if there's any negativity or bad publicity, or certain Republicans don't buy into this one plan over here, pretty confident with the employment-based backlog and these issues, where we can say, there's a lot of STEM candidates here that are in school, that they should have an easier path to go from F1 to H1B to GC, whatever that might be, how long ever long that might take. We want to retain that talent. So that's easier to sell maybe to people in the other party or to the public, rather than, quote unquote, like an amnesty that would benefit just anyone. So a lot of these issues are actually trending positive. Another big point that came out from President Biden's list of things that we need to address is the aging out of these kids that have pretty much grown up here in America, that came here as young children legally with their parents. Parents are in H1B status, kids are in H4 status. Now the kids are graduating high school, going to college. Parents have just recently filed for adjustment of status. How can we protect the kid from aging out? Which means the kid turns 21, no longer is able to qualify as a derivative under the parents' application and I-140 petition. So these are very important issues that are coming up. We'll have more clarity in the next couple of weeks to months. But these are the issues that I think, if they're piecemealed, meaning each issue is its own separate bill going through Congress, we have a higher chance of having these approved and passed than if we just try and cram everything together in one box and send it through.
Okay. Lucas, we discussed about the child age in December. We know that if any kid cross 21 years, they will not. They have to have changed the status H4 to the F1. Though, if any parent want to keep the child under the green card, what is the best way to lock the date? Maybe when they can lock the date, whether 485 adjustment of status application date or 485 final action date.
So what you're asking is basically, how can we get these applications moving to protect a child from aging out? Now, we do have certain regulations where maybe for employment-based applications, where if someone falls out of status or something happens, there's a 6-month period that's able to receive a waiver. So if there is an issue falling out of status between H4 to F1, there is a cure for that. Now, there is also a cure. We have something else called the Child Status Protection Act, which, if there's delay in processing the actual adjudication of the case, that we could recapture that time. Issue is on that, there's not really much recapturing of time on processing of these cases, because just because we can file the application doesn't necessarily mean there's been delay in processing the application if the final action date has not become current. So I think, for a lot of the candidates, and I've suggested this, to people who were filing last year, and it's really a case-by-case decision. I've always encouraged all my clients to go ahead and file for a child, even if it's close to, the date's close to the end of aging out, for the simple fact that if we have something pending and this year something changes where this issue is addressed and changed by law, if we have a pending application at that time, there's a higher chance that person or that child will be taken care of under these new provisions, where we don't lose an opportunity. Now, there's no guarantee, and I can't tell you for sure what's going to happen, but there's a high probability if something does come about, we're at least giving the kids the best opportunity possible to be included with the parents' GC application.
Let's say, Lucas, if any parent want to, let's say, a primary applicant apply the 485 adjustment status on October, their kid is maybe the 20 years and 6 months, maybe another 6 months, say, turning out to 21 years. If they want to protect their child, my question is, if can we do it? Well, you said is we can apply to the USCIS, or maybe you can apply to USCIS to lock the date. Is there any simplified way to approach to the attorney or approach to the USCIS to protect their child under adjustment of 485?
Well, there's a few different parameters that can be used potentially for this. Now, I want to back up and just remind everyone what we've always discussed in this forum is that we don't want to say everyone falls under one category. When you get into these types of issues, each case is independently unique. Now, what this means is just because it might work for person A, we don't want to follow. We don't always have the same results on person B. And so what we would need to do is have a individual strategy for each person. And, you know, I know I've spoken to a lot of people off this program where they've contacted me offline or through email to answer a few questions. And I try and always emphasize the fact that if you are getting just a one sentence answer or response from attorney on a complex issue, that's probably not the best route to take or the best person to talk to. You need to have someone look at your situation and analyze it for every possible outcome. Now, what this means is it doesn't mean that you might get a benefit or you might not. What it means is, you know, we need to try every possible opportunity that there is. And sometimes some of these opportunities, you know, entail extra work or maybe more creative thinking. But, you know, there is a lot of outcomes, a lot of different things that could happen, that each case would have its own unique set of facts that we would have to analyze to move forward, if that makes sense.
Okay. Lucas, I have a question on this one. My son will be age out next year in May. So we are now working on changing the status from H4 to F1, as currently the processing time of COS in US and more than a year. Should we think of getting this done in India, the consulate, or it means he's asking what is a
Correct.
highly appreciate, what is the best process?
Well, you see, this is another really good question that comes up time to time, and I'm glad for whoever sent the question in, you know, for bringing it up. The most important thing is when you're filing to change status from whatever status to F1, you know, you need to obviously work with the school, get a CVIS ID registered, get the I-20, and as long as you're not a visitor, like here on a B1, B2 visa, you can go ahead and file a change of status request with USCIS, and you can continue going to school because the application is going to take approximately 8 to 9 months. Now, here's the caveat that I always try and bring up to people. You know, right now we've had a challenging year with COVID, with pandemic and everything else. And there's been a lot of people who've had to make emergency travel back home. So what this means is if you have a pending application with USCIS for I-539 to extend or change a non-immigrant status, once you depart the United States, that case is automatically going to be denied for abandonment. So what it means is at that point in time, you're still going to have to go through the visa stamping process to come back in. So I would say it's not fatal to your case if you do that and an emergency comes up and you have to travel, but there's just extra, you know, circumstances involved. If you have the opportunity, like a trip's already planned and everything else, and the school's already on board getting everything set up, maybe it's more straightforward to just go and get stamped and come back in as F1. So, you know, each person has their own requirements, and, you know, each case should be looked at individually to make sure we meet the expectations of those clients.
Okay. The best way, I think, they should apply whenever the dates are coming, and maybe we are talking about the Biden immigration policy, the employment backlog. Do you have any update on this one?
Well, the employment-based backlog is one of the key points that's been brought up for this administration to address. Now, you know, in my point of view, and I'm sure all of our listeners' point of view, all these issues are more or less as important as one as the others. But we have to remember that a lot of these horrible things that happened under President Trump, have to be addressed first. So we have children who are separated from their parents at the border. There has to be focus, task force created to help rectify that problem. There's also, maybe other people impacted by, like these dreamers who are not really in status. They just have permission to work and, pretty much a promise that they won't be put in removal proceedings. That's what deferred action means. So maybe, those are higher priorities than someone who's here under H1B status waiting for the GC. Now, in the grand scheme of things, we're talking about maybe a few weeks delay on each of these, plans before it's implemented. You look back, it'll all seem like it was done at the same time, but that's what we hope to hear in the next few weeks. These plans for especially STEM students. This last year, 2 years, there's been a tremendous decline in our F1 students, our foreign students who come here for higher education, specifically masters and above, PhD students. And, our model as a country in the past has been to welcome anyone who wants to come to the United States for higher education, because we know that once they're here, A, they're going to have a higher degree that can contribute to society, and B, they're probably going to want to stay here. And we should accommodate that as much as possible so we can retain the top talent in the world. That's one of the things that has made America a great place, and that's something we need to have to continue the growth for our economy and our country. Now, I think that's the key focus of this administration too, is how can we get this profile of American education back up to being a world leader, or close to the top of being a world leader. And one of the things they can do is for STEM students, make it an easier pathway. Not only transitioning from F1 to H1B or some other visa, but then also within a foreseeable near future have access to GC or some temporary GC that allows you to have more stability rather than be on a non-immigrant visa like an H1B for 15 or 20 years.
Yeah, you're talking about the STEM degree advanced. Do you have any precise path maybe USC is going to implement, or USC is will bring this path to simplify the international students to get acquire the GC in US? Do you have any idea, as per your experience?
Right now, I don't have an idea. These are all policies that are being discussed. So we're at the very beginning of what these policy statements might be. And to go from a policy statement to actually debated and discussed and codified, which means, created into law, there's a lot of things that can happen in between. So what typically you want to start out with is just like if you want to compare agile methodology, you want to start out with the overall picture of what is the goal that we want to do. And that's what this is right here, is the main idea of what we want to do. And as we know in agile methodology, as we progress from one task to the next, we kind of flow like water to what's needed, and there's always things that come up that were unforeseen, or other things that we want to address at a later date. And that's more or less the same process we're following here. So to restate it, we're at the point now where we're introducing policy. It's basically just an idea without all the cogs to know how and why it happens, right?
Okay. Lucas, the last year, S386 and H11044 bills got approved Senate and House, but unfortunately got dead in the last year. So if the Biden administration and the per country limitation, what is their plan to end this per country quota for mainly for Indians and Chinese?
Well, so the plan is still, as we said in the policy stage, but what I would like to suggest, and what you and I have been talking about VinCap for a few months now, is what can happen is the legislative branch of our government, the House and the Senate, can write a law that says we want to clear this backlog for employment-based GC process. So what we can do is we're going to issue X number of visas that can be allocated to both China and India over the next 3 years. And after that, the number is going to go back to the way it was before. That's one way that's been done in the past. Another way would be we're going to, slowly take away these percentages of allocations for each country, the per country cap or per country limitations that we currently have, and we're going to open it up to where anyone can access the visas. Now, going that route, I don't think that's as feasible as just adding extra visas to get rid of the backlog, and I'll tell you why. A lot of our immigration system as it currently stands, it wants to focus on diversity, and we even have a diversity visa for countries who don't have enough people immigrating here. We have diversity lottery visas to encourage people from all over the world to come here, not just from certain parts. And that's a key factor of what our whole purpose behind our immigration system is we want equal access to come to the United States. So I think a lot of people want to see that remain the way it is. And I think the most efficient and effective way of maybe getting rid of the backlog would be to go ahead and just issue extra visas that can be used to, and this could be in the form of, hey, anyone can qualify for this visa if you have I-140 approved and it's been pending for 2 years. Something like that might allow you to move quickly and get the visa. So we'll have to wait and see, how people want to address this after, the policy discussion begins.
Okay. Yeah, we are discussing about the policies. Do you have any draft policies? Did you get any draft policies which are going to be?
Not yet. What we have is basically bullet points of ideas of issues that are going to be addressed. So, it's a good win right now for most of our listeners just to see that these policies are on the list. And like we said last week and the week before that, as these policies progress more to be discussed, that's when we want to start reaching out as a group, all of our representatives, all of our senators, coordinating with them and just letting people know how important this is to be addressed and passed into law.
Okay. Lucas, just before we discuss about the visa numbers, last year, maybe fiscal 2021, we know that around 260,000 visas added into the employment-based. Still, we are in February visa bulletin. The final action date is not moving out, actually. We got one question from YouTube from Shivani. What is the chance EB3 final action date reach May 17, 2010?
Okay, so there's a chance it could move up to that slot. Now, I do want all of our listeners to remember, due to the pandemic, the unused family-based or even employment-based visas from abroad were reallocated to the employment-based, like we predicted last October, to be used at that time. So as we discussed last week with delays in getting receipts and everything else, just today, the numbers I read from AILA, with the liaisons who work with the Texas Service Center, where a majority of these employment-based adjustments went, there's 415,000 pending adjustment of status cases, applications at the Texas Service Center on the Dallas lockbox. So that's not all people who are here on employment-based or anything else. It's just that surge of caseload has caused a delay, and we're still receiving receipts and checks being cashed for some cases filed end of last October, beginning of November. So if you can imagine just the sheer number of cases being processed, it's the same thing for maybe these the final action dates moving. You know, basically what happens is this: you file your adjustment of status case, but because the filing date became current. Okay. So that means that your application's being processed. It allows you to go ahead and get your employment authorization and advanced parole, but no one's going to actually work on the adjustment of status application until your final action date becomes current. So everything's put in its file. The file's put up on its shelf somewhere, and it's waiting there until your priority date becomes current with the final action date. Once that happens, someone has to go get the file again and begin processing and working on those cases. So there's usually a lag once these dates get close. You know, the officers have to go and pull however many files that are there that meet that requirement and process those cases. So I can see the cases or the priority date for final action date progressing close to that date. It's just a matter of how fast these other cases progress, if that makes any sense.
Okay. The same Shivani have another question about the aging out. If child age out, can we file F2B category while student on F1?
Well, yes. Once you go to the family-based category, of course, if there's a qualifying relative. Now, remember, for F2B, you have to be unmarried, son or daughter of a legal permanent resident. So that means to be a legal permanent resident, that means you've already been approved to have GC in hand. So you wouldn't be permitted to actually file that petition until you have your GC in hand or it's been approved. And then you're looking at restarting over for the priority date. Now, the priority date could be, I think right now is 2010 or 12, I think. So it's still some time waiting in that regards. So, but yes, proactively, that's a good idea to do. You know, this is where it comes important to work with an attorney to have that collaboration, to know how to best benefit the system so you can take care of the kids.
Okay, yeah, thank you. Hi, listeners and viewers. We are requesting you, if you have any question, you can dial to conference number and you can ask directly to Lucas. We are taking questions from you. Already we have a couple of from YouTube. We can address one by one. Meanwhile, if you have any, just you can post, or you can call and call to conference call, and you can ask to Lucas. Thank you. Yeah, Lucas, we have some questions from YouTube. Some Naru. My downgrade AOS received date is October 30th, 2020, and got rejection notice with receipt number for 485 due to application type field not completed. So his question is, so because of this other form also rejected 765 and 131, maybe depending if 485 got rejected, it associated all applications got rejected, 485, 765 and 131. Mm-hmm. They mention the package being returned and please send all pages of your completed application and fee. Payment to the address listed the bottom of the page Q1. Can we his question is, can we resubmit even though priority date is not current? The question 2 is, for resubmit, application receipt number would be same or different?
I'd have to know, what was the reason for rejection?
It did not mention it. So the rejection is application type field not completed. Just this is the information. Naru, if your seeing this, you can post or you can give the more details so we will try to give the more elaborated information on this.
So just in general, while we're waiting on him, just to go over that, if it was rejected because it was incomplete, not properly filled out, the form, that's an issue. Another issue, I've been receiving updates from IELA where we have, since some of these cases are still pending from October, if you submit a check, typically checks are good for 90 days, which means 3 months. So we're at November, December, January. With some of these checks might, be becoming stale. And so sometimes some of these packages might be returned because checks are stale. The bank won't honor the check because it's already past 90 days. So in this circumstance, what we have to do is, find out the reason for the rejection and then notify our liaison that works with USCIS to address the issue. I know depending on the specific nature of the rejection, there's some rejections that it's possible we could go ahead and rectify and send back because of USCIS error. But there's other rejections where we might have to wait for the priority date to become current again to refile. It just really depends on the details of the rejection.
Okay. Mainly his question is, can we resubmit the rejection 485?
The short answer to that would be not right now. But again, like I said, there's other people working with USCIS. I'm a member of American Immigration Lawyers Association, which references IELA. And, this is a large group of immigration attorneys. Now, if you can imagine, we get better results if we have one person out of all the thousands and thousands of immigration attorneys actually addressing our concerns to USCIS. So we have that person, which is what we call the liaison. And, we get examples from multiple different practitioners to send in recent examples of this happened, this was rejected because of this. And if we see a trend or something that's alarming mistakes from USCIS, that allows us to, work with them to say, if this circumstance A, B, and C happen, we can go ahead and resubmit the package and they'll accept it. So it really depends right now on two factors. The main reason why your case was rejected, number one. Number two, what USCIS might do to rectify that issue. And then, of course, number three would be hopefully the filing dates become current again once this backlog is addressed with the lockbox. Like we said a minute ago, there's still 415,000 applications that are pending, which means they've been mailed in and they're just sitting there. So, hopefully things move and things get better here soon.
Lucas, in this scenario, if primary applicant 485 got rejected, even if primary applicant is rejected, derivatives application also rejected, right?
Yes.
Okay. So if any possibility to resubmit this application, they can submit the primary applicant and the derivative application along with one single packet.
Correct. I have come across one of our viewers emailed me with this situation where they had a unique circumstance where one of their entire package was returned because they submitted checks for the adjustment of status application, and for the I-140 downgrade there was a check, and then for the adjustment of status applications they wanted to pay with credit card. So typically you're not permitted to file mixed methods of payments. If you pay by check, all have to be check or money order. If you pay using the form for credit card transaction, all have to be paid the same way. So that was one recent, rejection that kind of, was a little probably outside the normal scope of what normally gets rejected. And it's a bit comical because even though everything was mailed in one package, probably you could argue that each submission was its own package itself, so would not qualify to be rejected. So, we hear a lot of, odd circumstances on the rejection reasoning. So hopefully we can get all these corrected and move forward.
Okay. Lucas, we do have another question from YouTube, from Srivastav. GCEAD, can GCEAD be approved and issued without biometric completed or I-140 approval? Have you seen any such approvals received who fill in October 29-30? EB3 downgraded and file 485, EAD and advanced payroll.
I've had a few clients already receive their EAD and advanced parole. Those who've already received it, I believe they might have been a supplement J, so they weren't a downgrade case. But once you file the concurrent filing, it doesn't necessarily mean if it's a supplement J or not. Once the applications are accepted, each case process is the same. I've had a lot of people ask me, is it okay to go ahead and upgrade a premium for my I-140 to get this moving faster? And unfortunately, the answer is no. If you do premium on I-140 will be approved, but there's no rush to get the EADs and advanced paroles approved in the same 2-week time frame.
Okay. So I think his question is, will get GC EAD without biometrics?
No. If there was biometrics still on file, maybe if you had like a H4 EAD or something like that and it's still fresh, maybe. But typically, especially if you're H1, biometrics are going to be required. And if they're not required, there's some circumstance where they have your file on record and it's within a certain time frame that they can reuse it more or less.
Okay. So we can go for another question. Suhava. I have my AOS is pending for more than 180 days. I am currently working as consultant for a client IT department, and now I have an offer from some client, but from payroll department and with the same duties. I think the question is, will I any challenges in porting my AOS application as I am working for business instead of IT department?
Well, that is a very good question. Thank you for bringing that up. In the past, the answer would probably be, it wouldn't be that big of a challenge as long as we can show that the job is similar. There was a change probably 9 months ago to this porting ability within the field officer's handbook that is issued by USCIS. So what that means is there's more scrutiny now to make sure that your job duties are same or similar for the porting. So you probably need to speak to your new employer because I would imagine they're still going to have to transfer your H1 and you at that point of the process when you're going through that step, you might want to verify that the job duties, because that's really what it is. It's not so much the job title. USCIS has to review the job duties to make sure they're the same or similar to have that porting ability. And that's what I would recommend. And these are very, in the past, it was more straightforward. If you're, a developer, it's a developer, that would qualify. But now there's a little bit more background, looking into what the duties are to get that visa ported over or the application ported over.
Okay. Lucas, we are discussing 485 adjustment supplement J in this scenario. So if any H1 holder or if any 485 adjustment of holder want to change the job, it should be apply the supplement J after 180 days if they want to change one company to another company, right? So what is the date? That is, let's say it means if anyone submitted the 485 in October, maybe 25th, Which date is considered application date or notification date on the receipt? From
the receipt date. The receipt date, and then you count 180 days from that receipt date. So on the 181st day, you're able to port the adjustment of status application.
Okay. So most of this October applied for the downgrade. Can you suggest if who are applied it downgraded, they want to transfer the 485 to the another company, maybe without approval of I-140? Can you suggest, or what is a recommendation?
That's very risky because if your current employer, whoever petitioned for you, wants to withdraw that I-140 while it's pending, then obviously your adjustment of status application will be denied, and there's no purpose that you're not able to port at that point. So you'd have to go back through and do the perm process and wait for another priority date. So what I would recommend is, you want to make sure that you have an approved I-140 unless it's just an emergency. And then you want to wait after the I-140 is approved. You want to wait for 6 months so that your employer cannot revoke the I-140. Once you're at that stage, the way the Supplement J works is you can go to a different employer, and you can, however way this works, either through the GCEAD, or if you transfer your H1 or whatever status you have, you go to the other employer. As long as the job is same or similar, that's sufficient. Now, what do you have to do when I say Supplement J? Well, you don't have to do anything until USCIS notifies you, hey, we need an RFE because we're processing your case, and we need to make sure that you're still employed with the same employer, or you have the same or similar job function and duty with a different employer. And, you'll get an RFE in the mail, and, all you have to do is have your current employer fill that out and then send it back in with the RFE, and they'll continue processing the case at that time.
Okay. Lucas, adding one more question from Shivaji. He's asking how long one can stay without work after 180 days of adjustment of status.
Well, if I understand correctly, it's if you're out of status for 180 days. Is that the question?
I think, Shiva, the question is not clear. Maybe if you give them more detail, maybe we can address.
I think what he's referencing is the waiver. So, for employment-based, what happens is you have up to 6 months, 180 days. Maybe if you have unlawful presence or you're out of status, they can be waived, but if you exceed that, the waiver is not available, and you won't be able to continue adjusting your status. So, this is something that is unique to employment-based applications. If you are, for example, if we look on the other side, if you go to a family-based application, as long as you enter the country with permission, but you fall out of status, like you overstay a visitor visa, or you came here as a student and then you lost your CVIS and you're out of status, you can, even if it's 2 or 3, 10 years down the road, you can still adjust your status based upon, the family relationship at that point. So it's in context, you can look at it one way. On the family base, there's not really a penalty for it. Employment side, you have up to 6 months of unauthorized presence.
Okay. Lucas, one question is, my pre-ID date is current. I'm planning to travel to India on EAD and advanced payroll. What happens if GC issued? Can I still use my EAD to travel back?
So, yes. So the advanced parole allows you to go ahead and, get your, to travel and get back in the country and everything else. Now, whenever you're saying if GC is issued, if your final action date's current and they're working on your case, your GC could be issued, and then you can come back in. Now, it's very important. I had someone else ask me this today. What's the longest duration I can stay outside the United States on EAD advanced parole? And typically, of course, there's always an exception to if there's an emergency or something else, but typically you need to return to the United States before the expiration on that advanced parole. Okay. Currently, advanced parole and EADs are issued only for 1 year at a time. So it kind of limits the ability to travel and what you need to do just because you don't have access to those documents. So based upon that logic, it should, you would know if your case is really close to getting GC, because you're going to probably have to go in for an interview. You're going to have to send an RFE in with your medicals, with your supplement J, so that scenario probably wouldn't happen unless there was just a dire emergency where you had to travel. But you would probably have notice or knowledge that you're getting close to your GC being issued because you would receive these other notices.
Okay. Lucas, I have one question on H4. H4 extension has been denied. Case was applied through non-pro-trunk. Mm-hmm. How many days dependent has to leave U.S. border?
Typically, there's 20 days that you can, depart. Obviously, right now, if there's an issue where travel's difficult, or there's a health problem or something like this, you can always go to the airport with your ticket purchase and your itinerary, and you can request a deferred departure. Okay. At the beginning of the pandemic, this was something that was just issued all the time, that you could get a deferred departure from Customs and Border Patrol, and it wouldn't be an issue. Now there's a little bit more scrutiny involved. Maybe it's more of a case-by-case decision. Obviously, where you go, if it's DFW Airport, LAX, if it's Atlanta, all these international airports kind of have their own flavor of their own policies of what they would accept. So it's not something that you're guaranteed, but it's something you could definitely request. And like I said, at the beginning of the pandemic, it was something easily acquired, but now it's becoming more and more difficult. So if there is any underlying health condition where, you're afraid of travel, the vaccine's not yet available, or some other problem, you can take that evidence along with the plane ticket and the itinerary and show that to the Customs and Border Patrol officer at the port of entry at the airport, and they'll give you what we call that deferred departure. And if the same situation's there when the deferred departure expires, typically it's about a 3-month period, then you can go back again and request an additional deferred departure without accruing unlawful status.
Because this is first time I'm seeing this non-pro-trunk. What is this actually? When the USA is issued on this one?
So non-pro-tunc is a Latin term that pretty much, in layman's terms, is like you're going back to fix something, right? So it's like if you, to put it simple, if a non-pro-tunc is accepted, it's pretty much USCIS approving a decision, and that decision is effective from the previous date. Okay, so if there was typically it has to be due to circumstances outside the control of the non-immigrant. The non-immigrant has to be maintaining their status, whether it be if you're H4, F1, whatever it might be. You have to not be in removal proceedings, and you have to not have violated any non-immigrant status any other way. So there's 4 points to it. Typically, we see this the most common in H4s where, maybe an employer didn't file the H4 extension at the same time when they filed the H1B extension. Maybe, there's multiple reasons for this. But if that did happen and the non-pro-tunc did not work, you would still have the option, hopefully, of going and getting a deferred departure, especially if it's an H4 and you have kids. You could go and, for family unity purposes, it's not the right time to travel, COVID, things like this. that would be the next step to try and make sure you don't accrue unlawful presence.
Okay. Shiva provided the more details. The previous question. His question is I-140 approved and it more than 180 days that 485 is failed. Do we have any time limit before I switch to another employer? Like for H1, we have the 60 days grace period.
No limits on that whatsoever. And that these laws, I want everyone to remember, these laws are put into effect not to hinder you or to impact your life in a negative way. These are positive adjustments to our laws to allow you to have the freedom to move from one employer to the other, to where you don't feel like you're maybe stuck one place where you have other opportunities elsewhere. So, these laws were created with the intention of allowing you to have mobility as things change, because this process does take a long time, start and finish with this GC process. We all understand the longevity of this process. So these changes and implementations were made to help each individual move from one opportunity to another opportunity without any negative impact on them.
Okay. Yeah. Thank you, Lucas. We are reaching at 7 p.m. Central Time. Maybe we are at the end of the show. So thank you, Lucas. Today address about the fiscal H1B 2022 cap and a lot of the priorities of immigration H1B, the Biden administration policies. So thank you each and everyone who participated today and your valuable questions. We keep trying to provide the same momentum to this immigration community from Telugu NRI Radio. We are trying to simplify USA immigration, and we are trying to educate to each and everyone on USA immigration, so that you can take a right direction based on your scenarios and your situations. So thank you each and everyone who participated today, and each and everyone who tuned Telugu NRI Radio, the weekly webinar. Thank you from Telugu NRI Radio and Burgos and Law Firm. We can continue to the show every Wednesday, 6 p.m. Central Time. If any questions missed today, we can address in next Wednesday, and you can post. You can send an email to directly Lucas info@BGIMM Law. Get more information. If you have any complicated the scenario, maybe recommended to send email to Lucas and get more information, your case or scenarios. Thank you today. Ending the show. Lucas, you can say the end of the show. Yeah, you can address what if you anything miss.
I'll take a minute. I just want to thank everyone who participated tonight. It benefits not just us, but it helps the community. So any question, whatever it might be, please share, because there's probably someone else with a similar question or need that's going to benefit from it. And Venkat and I will tune in and have an emergency show if anything changes in regards to positive news. And a lot of things have been changing the past couple of weeks, so just stay tuned. Follow us on our Facebook pages for Telugu NRI Radio or Burgos and Garritson Law at BGM Law. And we'll try and update as soon as we hear any positive news or any news that might impact the viewers.
Yeah. Thank you, Lucas. Thanks for joining today, and bye-bye until next Wednesday. See you. Bye.